Welcome back, everyone. It's Anna Lautenschläger with Hot Seat with Anna. And today I have a super magical special guest for you. We have with us today Scott Topolski, a commercial litigator with tons of experience, who is the equity partner with GrayRobinson. Welcome, Scott.
Thank you, Anna. Very happy to be here.
Scott, we want to find out more about what business owners should do to hopefully avoid litigation. And most business owners believe that contracts protect them. So everyone has a contract, a client agreement, and everyone believes that they are as soundproof as possible. From your experience in court, though, how often do contracts fail when there is a dispute?
Sure. In a perfect world, contracts would prevent litigation, Anna. They don't. What they do, in all candor, is they provide a certain amount of certainty, for lack of a better term, and they can reduce litigation. But if contracts eliminated litigation, folks like me wouldn't exist, because the vast majority of disputes that I litigate and I try are contractual disputes. Because remember, you have two parties to a contract. Each has his or her own expectations. Each has his or her own perceptions about who is honoring that contract and who is not. So while contracts can, I think, reduce the risk of litigation, maybe reduce the number of lawsuits, they absolutely cannot prevent so many of the lawsuits that we see both in state and federal courts are suits for breaches, violations of contract. So yeah, that's why I like to say that folks go to my colleagues to put the deal together. They sadly come to me when the deal falls apart. And when the deal falls apart, that means somebody or both parties have not honored their obligations under the contract.
So, what kind of business disputes appear most often between partners, vendors, or clients? What do you
Sure.
see happening most often?
And contract disputes are the most common, Anna.
Mm.
It could, in a whole host of different settings, it can range from a vendor providing goods or services to someone who doesn't pay or doesn't pay in full. It could be, for an example, a roofer who does roof repairs or a roof replacement, and the workmanship is not
Mm.
appropriate and the homeowner sues. It could be an employee who has an employment contract and believes that the employer isn't honoring her obligations in terms of what the employer is supposed to pay. So the most common disputes that I get involved in as a commercial litigator are disputes involving contractual breaches, where one party says the other party isn't doing what he promised to do. And sometimes they're pointing fingers at each other. Party A says you didn't do A, B, and C, and party B says, oh, no, I did, but you didn't do D, E, and F. So contractual disputes, I think, are the most common type of business litigation matters.
Sounds to me like it's not much different from family law disputes where people get divorced and always fault the other party in the divorce.
I think that's a fair comment. You would hope that in business disputes, for the most part, it doesn't get as personal as family disputes, because it's kind of the cost of doing business. And I find when I represent businesses, that's usually the case. Not always, but usually the case. When it's individuals involved in a lawsuit, the line gets a little blurrier, a little
Yeah,
fuzzier.
I can see that. So many entrepreneurs try to kind of avoid legal disputes because litigation sounds expensive, it's painful. Are there cases where a business owner needs to fight instead of just settling?
Yeah, there is, and it could arise in a whole host of circumstances. I like to say that litigation is probably best suited for what I call high value or significant value cases, where the stakes are not quite as high. And I never want to minimize other people's money. Never. That's not my money. I never want to minimize it, but I do want to point out that for some cases, the legal fees associated with a dispute
Mm.
can be greater than the amount at stake. In the example I give people, do you really want to pay $50,000 in lawyer fees to get $30,000 back? Doesn't make sense financially. So I think, Anna, the higher you get, the greater the value, probably the more sense that it makes to consider the litigation route. In addition, it sometimes becomes really the only alternative. You're in a dispute with someone, that person isn't responding, that person isn't cooperating. the only way that you're going to, for lack of a better term, get the person's attention is to file a lawsuit.
Mm.
And that happens more often than not, probably in my business, at least, that where my client who is owed a substantial amount of money is being ignored. The other side is not responding.
Mm.
And you know what? We have no choice if we're going to get something from this resolution to file a lawsuit.
Yeah. Well, you mentioned contracts. What
Mhm.
clauses should every business owner consider including if they want fewer courtroom headaches?
Well, for me, and I'm admitted in Florida, New York, and New Jersey, but I practice in Florida. It's important to me to have what is known as a choice of law and a venue provision in it, meaning that if there is a breach or if there is a lawsuit, Florida law is going to apply. So there's language in there that indicates Florida law will apply. In
Mhm.
addition, and I have a client who I've represented for many years. They have what's known as a venue provision in their contract, which says that if there is a lawsuit, the lawsuit gets filed in Palm Beach County because
Mm.
that's where their business is located. So those are choice of law and venue provisions are important to me. I like to have a prevailing party attorney provision in there. This basically says if we sue you, and if we win, you're going to pay our attorney's fees also. So I think that is important. For certain types of matters, Anna, it may make sense to have a pre lawsuit mediation provision in there, meaning that if we get into a dispute before
Mm.
anyone goes to court, we have to go to pre suit mediation. We see that frequently with contracts to buy and sell real estate. The deal goes south, for lack of a better term, and there's money sitting in escrow, a deposit.
Mm.
It's very common to have a provision in there which says before anybody files any kind of lawsuit, you've got to go to pre-suit mediation. Because again, the attorney's fees can ultimately make a lawsuit cost prohibitive. It's better to try to get to the meat of this and get this resolved early on.
Awesome. Great advice. Thanks, Scott.
Oh,
Uh,
my pleasure.
I also hear that partnership disputes.
Hmm.
I don't have a partner in my company, but I hear from friends that partnership disputes destroy many successful companies.
You do.
What warning signs show partners are heading towards a legal battle?
Well, at the outset, there should be a very detailed written partnership agreement. There
Mm.
should be an operating agreement for the company that has language that addresses, amongst other things, what happens if there is a dispute. I often liken partnership disputes, Anna, to family law matters, except that instead of talking about a family partnership, we're talking about a business partnership, but they can get really, really acrimonious.
Mm.
I had a situation a couple of years ago, I represented a partner in a business down in Broward County. They got into a dispute and they locked him out. They
Oh.
physically locked him out. Now their position was he wasn't truly a partner in the business, and sometimes it can be difficult to get the court's attention to move on these things very quickly. So
Mm.
I think making sure that you have a written and generally speaking, when people enter into partnerships, there's usually a pre-existing relationship there. They may be longtime business colleagues, they may be friends, they may be both, and sometimes because of that, there may be an inclination to kind of rely upon a handshake agreement, which might have been great 60 or 70 years ago. In this day and age, we're a litigious society. It's best to have it all spelled out in writing. Again, not only with a partnership agreement between the partners, however many there are, 2, 3, 4, whatever, and an operating agreement for the company, which says, okay, if a dispute arises, here's what's going to happen. Because the last thing that you want happening is what happened to my client. And he literally got locked out, and he couldn't get access not only to the business premises, but to systems, to the computers, to bank accounts and such like that.
I'm shocked.
Yeah.
In these situations, business owners and similar situations, business owners often send angry emails or texts where disputes arise. How often do these messages then show up later in court and actually hurt the case?
It's a timely question that you asked, Anna, because I am scheduled to go to trial in the early part of April on a dispute where I represent an employer who is being sued by an employee who claims she wasn't she was an independent contractor, actually, not an employee. She was a commissioned salesperson. And let's say let's just characterize her text messages as rather visceral and emotive. They're not pretty for her, and they are absolutely relevant. And it's why I've always cautioned young attorneys when they're emailing attorneys on the other side uh, to count five sometimes before you send that email, because there's a natural reaction on many of us, particularly when we think we're right, to get our guard up and to fire off an email. And the
Mhm.
last thing you want to happen is that email to somehow get before the court. So
Mm,
always told young attorneys, when you communicate with attorneys on the other side, always communicate with the assumption that that email can ultimately get before the court and it won't
mm,
embarrass you. And probably, unfortunately, when we get cases, a lot of times clients have already been engaging in an email or text war, so to speak. So,
mm,
yes, they absolutely can get before the court. What I just described to you in our situation, thankfully, the text messages were on the other side. They don't
mhm.
paint her in a good light, and I have every intention of waiving them before the jury at the time of trial. Yes, absolutely.
Interesting, good to know. What mistakes in general, and maybe other mistakes, do companies make in the early stages of a conflict that later weaken their legal position in court?
Sure. I think one of the mistakes that people make is they kind of cut off communications, and just stop communicating. I had a situation, case resolved itself, I think late last year, but it was a contractor who was in a dispute with a homeowner. The homeowner had an attorney involved early. The contractor waited a little bit, and there was not a lot at stake here. In the greater scheme of things, it was a fairly small thing. And
Mhm.
I think if they had simply continued communicating early on, they could have avoided what probably turned out to be six figures in lawyers' fees a year and a half later. So communication, and sometimes it's difficult because it gets so acrimonious. I'd also advise folks not to necessarily wait to get an attorney involved. In this particular case that I talked to, mentioned to you, Anna, the homeowners already had an attorney. The contractor waited a little bit too long to get an attorney involved. He was trying to do some of the communications on his own. And the homeowner ultimately were trying to use those communications, those non-attorney communications, those non-attorney advised communications against the contractors. I fortunately was successful in keeping those communications out. If the other side has an attorney early on, even pre-suit, before a lawsuit, well before a lawsuit is entered, I think it's well advised that you also get an attorney involved and don't communicate with the other side's attorney. Get that that's what attorneys are
Mhm.
paid for. That's what they're trained for. That's what they have experience in. And it can save time and money, even though obviously it costs to hire an attorney. It can save time and money early on. If this
Mm.
particular client had gotten an attorney involved earlier, he may have avoided this whole dispute. And again, it turned out to be six figures in attorney's fees by the time the case was over. Yeah,
Awesome. I also know you work as a mediator as well,
I do. Yeah,
an arbitrator. Can you share with us why do some disputes resolve quickly in mediation? So some people go in mediation, reach the solution, everyone goes away happy.
sure.
Others, no matter how much they try, kind of explode into full litigation.
Yeah.
The factors or early warning signal mediation may not be the way forward.
Sure. So most mediations happen after a lawsuit is filed because the overwhelming majority of cases in Florida, once a lawsuit is filed, are at some point ordered to mediation. There are, however, situations where I will recommend to a client, before you file a lawsuit, why don't you think about seeing if the other side will engage in pre-suit mediation. Perfect example, I represent condo unit owners who are suing their homeowners association. There was an issue. They had a condo, I think, on the second floor, and there was an issue with the sloping outside of their unit, which caused significant water intrusion into their unit whenever it
Mm.
rained. And these were snowbirds, so they weren't at the property for a good portion of the year. And ultimately, it's forced them to gut the unit, probably to the tune of about $100,000 to repair that unit. Again, I do not want to minimize $100,000 when it's not my money. It's significant money. But in light of the fact that this is not what most courts would consider a very, very high value case because of the fact that we're dealing with unit owners on one hand and a homeowners association on the other. Had strongly recommended to do a pre-suit, and particularly when it's pretty clear this wasn't the homeowner's fault. They didn't do anything wrong. The only
Mm-hmm.
question was whether this was the association's fault, as we
Mm-hmm.
believe it was, or it was somehow an act of God, storm
Mm-hmm.
created. So when the issues are really, really simple, when they're really, really limited, and when maybe the value of the case isn't, a $500,000 or $1 million, those are some of the situations to think strongly about pre-suit mediation to avoid the costs of litigation going forward. But the reality is, even after you file a lawsuit, the overwhelming likelihood is at some point you will go to mediation. And my philosophy is, in litigation, it's generally preferable to get to mediation earlier rather than later,
Mm-hmm.
because the later it is, the more you have paid in attorney's fees, the more you are invested in litigation, the more you may say to yourself, you know what, I've come this far already. I've spent so much already. I might as well just go the extra 2 months, 3 months, whatever it's going to be.
Mm-hmm. Okay. Yeah, makes sense. Scott, thinking about a kind of final hot seat question for you. When a business owner, and I kind of got worried when you told us of that example of a business partner being locked out. I'd never heard of such thing, and it's
Yeah,
concerning. So when a business owner senses trouble with a partner or a client, what three steps should they take immediately before
sure.
the situation escalates into litigation?
Sure. I think step number one is to communicate openly and honestly with that partner, client, vendor, whatever. Like, you know what, here's the issue that we're having, and so that it doesn't turn from a code blue to a code red, so that's early, open, candid communication. Often that doesn't work. I strongly encourage at that point the client to retain a litigation attorney, not a transactional attorney, a litigation attorney, because
Mm-hmm.
litigation attorneys do more than litigate ongoing
Mm-hmm.
cases and try cases. Their initial or primary goal is to get a dispute resolved before even having to get to litigation, before even
Mm-hmm.
having to file a lawsuit, before having to go to trial or anything like that. So, uh, open communication doesn't work, and oftentimes it doesn't, because again, people have different perspectives, different views of life, different worldviews. Get a litigation attorney involved. Once it is, please, the third step, please rely upon the advice of that attorney. I can't tell you, I've had numerous clients who I have, we've consulted pre-litigation, and they'll go and they'll say, well, I put this question into Chat GPT, and Chat GPT tells me, and I'm like, okay, there's my 39 years of practicing law, and Chat GPT is going to tell me that, this is the way it should be. So listen to the advice of your attorney. That's what you're paying your attorney for. That's what you've invested your hard-earned dollars for. So communication, hire an attorney, and then once you do, listen to that attorney.
Scott, kind of was a script question, actually. I'm curious. I think some of us get lucky and have great attorneys, and I work with you.
Thank you, Anna.
Help me
Yeah, I, I,
litigate
I told you I'd
my
like to have 5 more
company,
clients like you.
and you're doing fantastic job. I wish there is 10 Scott Topolskis
Thank you.
or more. But more often than not, we get attorneys where trusting in the advice is difficult because it can be kind of unclear at best, and it may sound like very not unconvincing, but where attorney himself sounds pretty unsure, and there are different options. He
Right.
cannot really advise on the preferred way forward. How do you actually find a good attorney? What kind of questions should you ask an attorney? Because
Yeah.
trust, we all meet with an attorney. They, of course, we trust that they, bar admitted and know what they're doing. But how do we know that they know what they're doing? With
Of
companies like
course.
GrayRobinson, of course, they have stellar reputation. So I'm sure no one is inviting an equity partner to work with them.
Sure.
They are not a badass at what they do. But there are a lot of smaller providers you just don't know. So how, as a business owner or as a person in need of legal advice, you actually make sure that you select an attorney who knows what
Yeah.
they're
It's a difficult decision, and it can be an
doing.
expensive decision, Anna. So you want to make sure it's the right decision. I get so many referrals from other attorneys, word of mouth, existing clients. I've also gotten some clients through the years that I actually had sued, had been on the other side of the
Mhm.
case resolved, and they came back to me. So I think, tapping into your own network of trusted professionals, trusted colleagues, trusted friends,
Mm.
business associates is the best way to start. You see advertisements on TV all the time. For
Yeah.
the most part, it's one segment of the law that you see advertisements for. I can't really speak to whether that's wise or not to trust that. I mean, from my perspective, the most success comes for clients when they tap into their own network of, again, trusted colleagues,
Mhm.
business associates, friends who've had experiences with,
Mhm.
attorneys in a given area and can recommend that attorney. That's the best place to start. Look, there are all sorts of, I guess, resources online that we can go to these days, whether it's LinkedIn, go to Florida bar websites, Martindale Hubble, whatever it is. But for me, nothing. And this goes when I'm hiring the professional too. If I'm hiring an electrician, if I'm hiring a roofer, I'm going to go to someone who's had a good experience with
Mm.
someone who has done work similar for that person. So I don't know that it should be any different for an attorney. Once you
Mhm.
meet with that attorney, you've got to get a comfort level that, he or she does this type of work,
Mhm.
has a proven track record, has experience, because look, like anything else, experience matters. And I think you'd rather have someone who's been doing this for 30 or 30 plus years rather than someone who's been doing it for 2 years, or 3 years. So trust your network, and then make sure that you speak with, kind of interview almost, that attorney to confirm that this attorney has the goods, so to speak, what you need.
Thank you. I just curious. I actually have quite a lot of friends who are lawyers or attorneys, but most of them hate litigation. So
Right.
most of them focus on the transactional side of
Sure.
things in all fields of law, actually. And
Yeah,
they find litigation very uncertain, very stressful, and that clients are usually very emotionally charged when it gets to that stage. So
it
it's
is.
difficult to navigate through that emotional side of things as well. So how did you end up being a litigation attorney?
It's a good question, and it was. I don't know that it was necessarily intentional. Anna. I went to law school back in the mid '80s, so 1984 to '87. I knew certainly as far back as high school that I was going to be going to law school. I wasn't really sure what that entailed or what that meant. Back then, I had a thought that I might use law school to go into politics, because most politicians were lawyers back then. I think
Hmm.
still are, probably. Not all,
Yeah.
but a lot. But that's a really tough way to make a living. It's a tough family life. You have to compromise values and principles. So I kind of happened into litigation. I do like to write. I do like to speak in public, and it just kind of morphed into that. It wasn't anything intentional. It's not like I had this aha moment, like, oh yeah, I want to be a trial attorney.
Mm.
Went to law school, kind of gravitated toward the more classes that kind of set the foundation for being a commercial litigation attorney. And here
Mhm.
we are 40 years later. So,
Interesting you would mention politics because I'm a huge fan of the series called The West Wing. It's like 30-year-old political series, I think.
right.
And they just came back on, not came back, but appeared on Netflix. It's
Oh,
actually
okay.
difficult, you couldn't even download the series anywhere as long as you don't have them on a DVD. Back then you couldn't watch them anywhere. So
Right.
I'm watching them on Netflix at the moment with Lee. And you actually keep reminding me there is an attorney, Sam Seaborn, which is Rob Lowe's character. And I told Lee a couple of days ago that he reminds me of Scott, the way he operates. So it's
Oh my
fun.
gosh. I
Politics.
should lucky.
Well, I know Scott a little bit, and I know that Scott is not just an attorney. And
No.
attorneys sometimes get that bad reputation of being, ruthless, not caring for clients. Scott is very different. I know that he supports not just a number of charities, but every possible initiative, any possible opportunity to help someone in need. He always says yes to everything. And Scott has an interesting dog with an interesting story. So, Scott, I'll let you tell the story because I feel it gives a little bit insight who
Sure.
you are as a person, like more human side of,
Of
the legal.
course. So yes, we have a Phoenix who we had adopted. Oh my gosh, 6, 7 weeks old, I think. We were told he was a Goberian, which is a golden retriever Siberian Husky mix. We actually rescued him from the golden retriever rescue of South Florida, and my wife actually went to. He came from overseas. My wife actually went to a house in Coral Springs, I think at 1:30 in the morning to pick him up that day. His
Mhm.
brother actually was adopted by a family that lives about 2 miles down the road. So they've gotten together for play dates, but he's definitely not a Goberian. I mean, he's got Husky in him. He's got German Shepherd in him. He's got a little bit of Golden Retriever in him. I mean, he's got Chow in him. It's funny to say he's a pure mutt, but he's a pure mutt. And he's a great dog. A little bit crazy, but he's a great dog. But my wife Nancy and I have been married for it'll be 34 years next month, and
Okay.
all but 1 month of our marriage we've had a dog. We went out a month after we got married looking for a Mother's Day present for my mother, and we came back with our first dog, and we've had dogs ever since. So yeah, we are. And I have a daughter who's a veterinarian, so we're definitely a dog and an animal family.
Absolutely. You have another daughter who is going to become a lawyer.
She is in her second year at Duke Law School. She's just finishing up her second year. She'll be working in New York and living in New York this summer. So she has a little bit more than a year of law school to go, and then she'll join me in this esteemed profession.
That's quite a legacy. I love it.
Thank you, Anna.
I also know that you are due to be locked up with a horse again. You're going to jail with a miniature horse in October.
Yes.
Is the rumor true? Tell us a little bit about that.
Yeah, I would imagine it will be. So Tomorrow's Rainbow, which is a organization out of Coconut Creek, Florida, that provides support to grieving children. They have a fundraiser every October. You and I both participated in it this past October, where it's their big fundraising event. And as part of the fundraising, certain persons are, for lack of a better term, or quote unquote inmates. They get locked up in a pen with a miniature horse, and they have to stay in that pen until they have hit their fundraising goal. Last year, thankfully, I had hit the goal before I even got into the pen, but I stayed in the pen for about an hour or so because the horse is so cute, and then came out. So I would expect that I've done that the last few years. I would expect that I'll do that again this year. Yeah.
Well, thanks so much for your time.
Oh,
I
thank you. I appreciate it, Anna.
really enjoyed talking to you. So here, ladies and gentlemen, Scott Topolski for you, an attorney who is not afraid of going to jail with a miniature pony. Thank you for your time.
Thank you, Anna. Have a great day. Okay.
You too.
Bye bye.